Good day everyone, I am Kyle Adrian Arditiosa of Bachelor of Science in Criminology, Section 1E2. In this video, I will summarize all the lessons that I have learned in the subject of CLJ or Criminology, Law and Justice. And also this video covers the study of the 5 pillars of the criminal justice system in the Philippines. The law enforcement, prosecution, court, correction, and community. Also this video covers the respective functional relationship as well as the individual roles in the administration of justice and solution of crimes. So without further ado, let's begin. First, the criminal justice system is the machinery which the society uses in the prevention and control of crimes. It may also refer to the totality of the activities of the law enforcers, prosecutors, judge, and correction personnel, as well as those of the mobilized community in crime preventing and control. In theory, criminal justice system is an integrated apparatus that is concerned with the following: apprehension, prosecution, trial, conviction, sentencing, and rehabilitating or correcting criminal offenders. And the goals of CJS is prevention of crime, protect members of the society against crime, maintain peace and order, suppression of criminality, review the legality of existing rules and regulation, and last is the rehabilitation and reformation of offenders. And also, people involved in the system, or which is called the parties to the criminal case, are the accused, victim, or complainant. And last is the people of the Philippines. Accused is the most pampered party in a criminal case, while victims and complainants, the forgotten party in a criminal case. And also, the people of the Philippines is the actual offended party. The Philippine criminal justice process is undergoes in the 4 pillars, which are the law enforcement pillar, prosecution pillar, court pillar, and last is in the correction pillar. In the process of law enforcement pillar, a person who has violated the law is apprehended by the police or any enforcement agency like the NBI or narcotics groups and etc. But the case may be diverted where no sufficient ground can sustain complaints against the suspect, reverted to the community. In the prosecution pillar, offenders are prosecuted for the alleged offense committed, but the case may be diverted where no probable cause can sustain a prosecution, reverted to the community. And in the court pillar, offenders tried before the court, but the case may be diverted where the evidence is enough for conviction of the offenders, and it will be reverted to the community. And last, in the correction pillar, if the offender is convicted, either serves his sentence in jail or prison or is placed on the probation. In case of imprisonment, full service of sentence diversion takes place through the grant of parole, conditional pardon, probation is by itself, a diversion process reverted to the community. I learned about the essence of justice. First, what is justice? Justice is the act of rendering what are due and treating persons equally. This person must fall within the same classification. And also essence of justice under the Philippine Constitution, under Section 1, Article 3 of the 1987 Philippine Constitution, no person shall be deprived of life, liberty, or property without due process of law, nor shall a person be deprived of the equal protection of law. This guarantee dictates that in order that justice will be realized, there must be the observance of due process. Due process is the guarant against any arbitrariness on the part of the government, whether committed by the legislative, executive, or the judiciary. And the kinds of due process are the procedural due process and substantive due process. Procedural due process is the one which hears before and condemns, which proceeds upon inquiry and renders judgment only after trial. While the substantive due process, this requires the intrinsic intrinsic validity of the law interfering with the rights of the person to his life, liberty, or property. The third lesson is the law enforcement pillar. Law enforcement is considered as the prime mover of the criminal justice system. Law enforcement is a deterrent and preventive activity. And the different police activities in law enforcement is prevention of crime is intended to prevent root causes of crime. Repression or suppression of crime is done to reduce the opportunity of committing a crime, like the act of conducting patrol. And apprehending offenders is also known as arresting offenders, conduct search and seizure, investigation of crime, and protection of life and property. In the Philippines, the law enforcement function is spearheaded by the Philippine National Police or PNP, the Department of Interior Local Government or the DILG, and the National Bureau of Investigation or NBI under the Department of Justice or DOJ. And the goal of the PNP is prevent and control crimes and maintain peace and order. And last is ensure public safety and security. Also, in this system, it includes the community-oriented policing system, or also called the COPS. This was established for the law enforcement and community to have a harmonious relationship with each other. Under this system, the policeman conducts seminars, tree planting, and other activities for them to show how much they care for the community. In return, the community will have an active participation in assisting the policeman in performing their official functions. And the fourth lesson that I have learned is all about the law enforcement pillar. We have a natures of the police service. First, the home rule, and second is the continental. First, home rule. Home rule is policemen are considered as servants of the community, while the continental is policemen are considered as servants of the higher authority. And the concept of the police service, we have two concepts of police service. First, the old concept, and the modern concept is the second. First, the old concept. The old concept is the yardstick of the police efficiency is the number of arrests. Police is a repressive machinery in crime prevention. While in modern concept, the yardstick of police efficiency is the absence of the crime or lesser the number of crimes committed. Also, we have police discretion. Police discretion, it is the wise use of one judgment, personal experience, and common sense to decide a particular situation. Abuse of discretion resulting to injury to person or damage to property is punishable. So the police must be guided by the same basic concepts such as common sense, personal experience, and sound judgment. Also, we discuss about the law enforcement pillar. In law enforcement pillar, we talk about the arrest, manner of conducting arrest, warrant of arrest, and etc. First, what is arrest? Arrest is the taking of a person into custody in order that may be bound to answer to the commission of an offense. And the manner of conducting arrest, an arrest is made by actual restraint of a person to be arrested, or by his submission to the custody of the person making an arrest. While the warrant of arrest is an order in writing issued in the name of people of the Philippines, signed by the judge and directed to the peace of officers, commanding him to arrest the person or persons stated therein, deliver them before the court. And here are the requisites of valid warrant of arrest are the following. First, it shall be issued upon the probable cause. Second, the probable cause is determined personally by the judge upon examination under oath or affirmation of the complainant and witnesses he may produce. And last is the particular describing the person to be arrested. It includes in the section 2, article 3 of the Philippine Constitution. And the lifespan of a warrant of arrest, as long as the person is stated in the warrant of arrest is not arrested, it shall remain valid even if several years already lapsed. However, the head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days after the expiration of the period. The officers to whom it was assigned for execution shall make a report to the judge who issued the warrant. And also we talk about the warrantless arrest. This is a peace officer or a private person may arrest a person without a warrant when in his presence the person to be arrested has committed, is actually committing or is attempting to commit an offense. When an offense has in fact just been committed and he has personal knowledge of fact of indicating the persons to be arrested had committed it. And when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. Search and seizure. Search is defined as the act of looking into carefully in order to find some concealed items, while seizures is to take into custody of something. Uh, Here are the power to conduct a search. In general rule, a warrant is needed before search. Validity of warrant is 10 days from its date. In warrantless search, search is incidental to lawful arrest. A person lawfully arrested to may be searched for a dangerous weapon or anything which may have been in use or constitute proof in the commission of an offense without search warrant. In consented search, the right against unreasonable search and seizure may be voluntarily waived by a person being searched. In plain view doctrine, illegal things at sight may be seized even without a warrant to do so. The things must be readily seen without any efforts of locating it. Search conducted by Bureau of Customs, search conducted by the security guards and last in search in moving vehicles and checkpoints. And under search in moving vehicles, especially in checkpoints, moving vehicles may be searched provided that is limited visual search. When to serve search warrant? The search warrant must direct that it be served in the daytime, unless the affidavit asserts that the properties on the person or on the place are ordered to be searched, in which case direction may be inserted that it be served at any time of the day or night. The prosecution pillar. Prosecution is the process of method whereby the accusation are brought before the court of justice to determine the guilt or innocence of the accused. Serving as the lawyer of the state government in criminal cases, the prosecutor is automatically considered an officer of the court. At the same time, he is formally a member of the Department of Justice under the executive branch of the government and thus independent from judiciary. The prosecution service is made a provincial and city public prosecutor under the National Prosecution Service or NPS. They perform two types of prosecutorial powers, investigatory and prosecutory, such as they evaluate the police finding referred to them or other complaints filed directly with them by individual persons. Example, government officers in charge of enforcement of law violated. They file corresponding information or criminal complaints in the proper courts on the basis of their evaluation of the proofs at hand, and they prosecute the alleged offenders in court in the name of the people of the Philippines. Prosecutorial discretion typically enters the pictures immediately after the arrest, when the police is investigative reports are forwarded to the prosecutor for review. The prosecutor screens and evaluates the document in order to decide whether to accept or reject the case for prosecution. The action of the prosecution is dependent upon the police initiatory action, whereby the criminal justice system relies on the certainty of the arrest by the police, certainty of conviction by an effective prosecution, certainty of appropriate sentencing by court. Court pillar. Court is a government institution that decides a case according to the existing laws or the laws of the land. It adjudicates legal disputes between citizens or between the citizens and the government. While judge is a public officer so named on his commission and appointed to preside over and to administer the law in court of justice. And here are the composition of the Philippine courts. Here are the regular courts. Supreme Court. Supreme Court, it is the highest court in the Philippines. Court of Appeals. It is the second highest judicial court after the Supreme Court. It reviews decision and orders of the lower court. And the third is the Regional Trial Court, or the RTC, has a jurisdiction over the offenses punishable with the imprisonment of 6 years and 1 day and over. And Inferior Court is a Metropolitan Trial Court or Municipal Trial Court or Municipal Circuit Trial Court. Has a jurisdiction over a violation of city municipal ordinances and offenses punishable by imprisonment not exceeding 6 years. And here are the special courts. This is what we called Sandigang Bayan and the Court of Tax Appeal, or CTA. In Sandigang Bayan, it is the special court that has a jurisdiction over criminal and civil cases involving a graft and corrupt practices of public officers. It is created pursuant to PD 1606. And while the Court of Tax Appeals has exclusive appellate jurisdiction to review and appeal the decision of the commissioners of the Bureau of International Revenue involving the internal revenue taxes and decision of the commissioners of the Bureau of Customs involving custom duties created in pursuant to Republic Act 1125. And it's also have Sharia Court or Sharia District Court, Sharia Circuit Trial Court, and we have Family Court. Sharia Court is created pursuant to PD 1083, otherwise known as the Code of Muslim Personal Laws of the Philippines. Cases brought before this court is civil in nature. While the Family Court is this special court was established by the virtue of Republic Act 8369, otherwise known as the Family Court Act of 1997. It covers criminal cases where one or more of the accused below 18 years of age but no less than 9 years of age, or where one or more of the victims in a minor at the time of the commission of the offense. Correction Pillar. Correction is a branch of the criminal justice system in concern with the custody, supervision, and rehabilitation of criminal offenders. And also, we have a penology. Penology is the study of punishment for crime or of criminal offender. It includes the study of control and prevention of crime through punishment of criminal offenders. Here are the classification of correction. Institutional correction and non-institutional correction. Institutional corrections deal with the jails, prisons, and colonies where our convict is going to serve his sentence, while in a non-institutional correction deals with the service of sentence or convict outside an institution. This is also known as a community-based treatment. And we have 5 justification of punishment. Retribution. First, offenders should be punished because they deserve it. Second is expiation or atonement. It is a punishment in the form of group vengeance, where the purpose is to appease the offended public or group. The third is deterrence. Punishment gives lesson to the offenders by showing to others what would happen to them if they violate the law. And fourth is the incapacitation and protection. The public will be protected if the offenders is being held in condition where they cannot harm others, especially the public. And the last is the reforming or rehabilitation. It is the establishment of the usefulness and responsibility of the